A process that's oh too familiar to us here in California, where you get a good decision from a federal district court, a bad one from the circuit court, and then the Supreme Court tells you to go ahead and get a judgment. Well, in FFLs of Illinois versus Pritzker, we finally got that judgment. This lawsuit has to do with magazine bans and assault weapons, maybe going to the Supreme Court. Let's talk about it. Hey everybody, welcome back to the channel today. We have got more news on bans for magazines and assault weapons. This one coming out of the state of Illinois, and a good decision at that. To talk us through it, this of course is FFLs of Illinois versus Pritzker. We have brought back on a friend to the channel and an attorney at Michelle & Associates. That is Costas Moros. Costas, thanks for coming on.
Hey Kevin, great to be back as always.
Absolutely. And guys, before we get into it today, please be sure to like, share, and subscribe to these videos. It is a great way to directly contribute to Second Amendment litigative and legislative efforts in the state, as everything that comes into CRPA here is purely focused on just that. So, Costas, if you could just walk us through this here. I know that we've done a little bit of talk on some of these cases out of Illinois. This one, FFLs of Illinois versus Pritzker, had one part that is very near and dear to litigation that we have here in California. Part of it isn't, but could you just go ahead and let us know, what is this lawsuit and how has it gotten to the point where it's at today?
Sure. So this lawsuit. It's actually four lawsuits in total. The one our office has worked on is FFL v. Pritzker, but there's four of them in total, and all of them challenged the relatively new Illinois assault weapon ban, the Protect Illinois Communities Act. They call it PICA. And that one put in a ban on assault weapons, similar to how California's is, although it's a little bit stricter than California's actually. And it also bans magazines over 10 rounds for rifles and over 15 rounds for handguns. And finally, it requires registration. If you were already an owner of these firearms before the law happened, you can keep them, but only if you register every rifle, shotgun, pistol that's under the act, every magazine individually, and even individual rounds of 50 BMG ammo would have to be registered. So that's what we challenged. We won a preliminary injunction in 2023 against the law, but then it was reversed by the Seventh Circuit last year in a case called Bevis v. Naperville, because we got consolidated with another challenge. And we went all the way up to the Supreme Court, and the Supreme Court basically told us, interesting case, but come back to us after a final judgment. We even got a write-up from Judge Thomas concurring in the denial of cert, basically saying we should decide this question, but not on a preliminary injunction. So as we've seen, the Supreme Court has a preference for final judgment. So we rushed back down to the district court and moved at relative light speed. Full credit to my colleague Sean Brady and the attorneys for the other cases. I was not that involved in the trial. They worked it up fast, and they presented hundreds and thousands of pages of evidence, answering, all the evidentiary questions, and they had a trial in September. And now finally, we have a final judgment rolling from Judge McGlynn in our favor with some asterisks. There's a couple things the cases did not prevail on, but mostly they did prevail.
So, yeah, so you've got, a process that's so familiar to us here at CRPA and California litigation in general. You've got a case that you have this ban on firearms products, essentially. It's taken to court. You get a good decision from the district court. You go up to the circuit court. They basically take everything away from you. Then you appeal to the Supreme Court. They say, wait for a final judgment. So we go down and get the final judgment in favor of the Second Amendment. I wanted to get your thoughts on this because I was reading through some of this, some of the opinions that have come out from the federal district court as well as the Seventh Circuit Court over there. I found some of this kind of interesting, and I guess interesting in a way that it so very much parallels California and the lawsuits that we have here. From the original preliminary injunction that was put on, the opinion said this. Jacob, if you could actually bring it up. It reads like this. Plaintiffs claimed that the assault weapon ban enacted by PICA is unconstitutional as it contravenes the Second Amendment right to keep and bear arms. For some constitutional violations, particularly involving First Amendment claims, irreparable harm is presumed. Although the Supreme Court has not recognized the presumption of irreparable harm in regard to the Second Amendment violations, it has emphasized that the Second Amendment and the constitutional right to bear arms for self-defense is not a second-class right. Of course, that's Justice Thomas at the Supreme Court level in the Bruin decision, if you guys remember, subject to an entirely different body of rules than the other Bill of Rights guarantees. When a law is facially challenged under the Second Amendment, the form of the claim and the substance of the Second Amendment right create a harm that is properly regarded as irreparable and having no adequate remedy at law. Assuming arguendo that there is no presumption of harm for an alleged violation of the Second Amendment, plaintiffs still satisfy this element. For example, Barnett and Norman are no longer able to purchase a firearm, attachment, device, magazine, and other items banned by PICA, while Hood and the Pro Gun are now prohibited from selling any item banned by PICA. These harms are irreparable and in direct violation of the Second Amendment right to bear arms in self-defense. There is no question that the right to armed self-defense is limited by PICA and in some cases may be prohibited altogether. It is true that not all items are banned under PICA. However, if a lawful citizen only possesses items that are banned under PICA, he or she would have to purchase a non-banned firearm in order to legally defend oneself under the Second Amendment. So, I guess the question that I'm curious about, this is pretty defining to me where this judge is coming from. He's basically saying that there's no presumption, that currently in the court system that a Second Amendment claim should automatically, get a preliminary injunction. Is this something that we see commonly in California, whether it be the Ninth Circuit or in the federal district court? And how spot on do you feel like this argument is?
Well, it can vary from circuit to circuit in terms of what they presume for harm. There should be a presumption of harm because the Second Amendment, again, shouldn't be a second-class right. But it is true that courts especially hostile courts, do not seem to take us seriously when it comes to preliminary injunctions, especially because they don't like us and they want to rule against us because they don't like the Second Amendment. So that's why we get stuff like arguments that, well, even if you can't have a magazine over 10 rounds, you're not irreparably harmed because you can still have a magazine of 10 or less rounds to defend yourself with. That's fine. There's no irreparable harm there. But nobody would make that argument in the First Amendment context. Nobody would say, hey, if we ban you from having a YouTube channel, that's okay because you can still, write a letter to the editor of your local newspaper. Like it's presumed that it's harmful no matter how it restricts you, even if there are alternatives. And that's how it should be for the Second Amendment as well. But it is, hopefully the Supreme Court eventually comments on this. That's why it would have been great. I know they don't like to take preliminary injunction cases, but it would have been great for them to clarify that sort of issue up, and make clear that this shouldn't be treated as lesser than the First Amendment.
Yeah, I guess so. If you're thinking about setting a precedent that the Second Amendment isn't a second-class right, we have to define how it's being treated as a second-class right, maybe a little bit further for the lower courts. I got another quote here, Jacob. If you could pull this up from the same opinion. You're talking about a direct correlation to the Duncan case here that I thought was pretty interesting. It reads like this. The court will first address defendant's contention that non-essential accessories are not within the scope of the Second Amendment's plain text. The judge then goes on to list a bunch of things that PICA outlaws and then picks up right here. PICA further outlaws possession of a magazine for a handgun capable of holding more than 15 rounds of ammunition and of a semi-automatic pistol that has a fixed magazine with the capacity to accept more than 15 rounds. Defendants contend that such items are not necessary to the functioning of a firearm and are thus not arms and therefore not protected by the Second Amendment. Defendants defendant's argument is not persuasive. The Seventh Circuit has recognized the Second Amendment as extending to corollaries to the meaningful exercise of the core right to possess firearms for self-defense. It is hard to imagine something more closely correlated to the right to use a firearm in self-defense than the ability to effectively load ammunition into the firearm. The Third Circuit Court recognized this importance of the corollary held in a magazine is an arm under the Second Amendment. Further, defendants' own expert defined high-capacity firearms as handheld arms with a capacity greater than 10 rounds, recognizing that the Illinois statute allows up to 15 rounds for handguns. Defendant's expert is clearly referencing magazines and incorporating such into his definition of a firearm. This court agrees that magazines are arms. As used in the plain text of the Second Amendment, plaintiffs are correct that this is not even a close call. So basically the same argument that we made in the Duncan case, this is sounding very eerily similar to something that Judge Benitez would have wrote. I guess what I'm curious to hear your opinion on is, in seeing an opinion like this, seeing an opinion that Judge Benitez would write on the Duncan case, do these help each other out in the system at all? I understand that one's in Illinois, one's in California, but are these lawsuits getting referenced when they're being argued moving forward as they continue to progress through the court system?
Oh, sure. I mean, Judge McGlynn in his ruling last week definitely cited Duncan and Judge Benitez a couple of times, if I remember correctly. So they do get cited, and they provide some comfort to judges that they aren't going out on a limb, like somebody else agrees with them. So it is helpful in that sense, and it helps them develop these arguments. But ultimately, it's going to come down, of course, to what the circuit courts say, especially and particularly the hostile circuits, because they're the only ones that ever hear assault weapons cases. So. And in this case, this argument that so-and-so thing isn't an arm is one we've heard again and again and again. Oh, magazines aren't protected because they aren't arms. They aren't a gun. Well, what Heller defined an arm as is anything you take into your hands to cast at or strike another. It's an arm. So a magazine is part of the firearm, so it is an arm. You can say, maybe they can argue that, while it is an arm, there's reasons to restrict it based on historical tradition. They could try and make that argument, but they can't get around what they're trying to do is get around Bruin, avoid the historical analysis that they know they'll lose by arguing that something isn't an arm in the first place. And more courts, by the way, are starting to notice this. The DC Circuit upheld a ban on magazines, I think over 10 rounds, I think it was. Just a couple weeks ago, but they rejected the argument that they're not arms, at least. So while I disagree with that ruling, it at least had the intellectual honesty to say these are arms, but we're going to uphold the ban based on a historical tradition of restricting, I think they called them exceptionally lethal weapons, and they compared them to Bowie knives, which is ridiculous. But you're seeing more courts reject the silliest arguments, which is a good thing. We're moving the ball forward, albeit slowly, I guess.
Well, I suppose one court that would not be looking to circumvent the Bruin decision is the Supreme Court. So I'm curious, what are your final thoughts on this case, FFLs of Illinois versus Pritzker? Does it have SCOTUS in its near future now that we've reached a final judgment? And how do you see that playing out potentially?
Well, I'll be able to answer that question a lot better in about 4 to 6 weeks, because we're going to find out if the Supreme Court is going to grant cert or not on a case called Snope v. Brown out of Maryland, an assault weapons case. If they grant cert on Snope v. Brown, I expect that the Seventh Circuit hearing this appeal and the Ninth Circuit in Duncan, for that matter, if they still haven't issued Duncan by then, are probably going to put their cases on hold until Snope is out by June, because the Supreme Court would be saying we're about to give guidance on this question. So we'll see. But if the Supreme Court were to reject cert on Snope, which would be very disappointing because that one's a final judgment too, then that would mean that either this case or our other case of Duncan would become the front runners to be the next chance at the Supreme Court. But it would be pretty depressing, I'd say, if they deny cert on Snope. Then that might mean they don't want the issue right now, which would be a bad sign. But of course, we're going to keep fighting either way to try and get this up to the Supreme Court, regardless of the odds. But everyone keep your fingers crossed for Snope. I think that'll be a great sign, especially after the election, because there's been this fear that the Supreme Court wants to try and avoid controversial issues because of the threat of court packing. Well, with Donald Trump's victory last week, that's not happening. There's no threat of court packing, and also the circuit courts have no reason to delay anymore, because even if they were trying to wait out Justice Thomas or Justice Alito in hopes they retire or die, frankly, now Donald Trump would replace them. So there's no reason for them to stall. So that was, I think, real good sign for us, but it's still going to come down to the Supreme Court doing the right thing and accepting cert.
Well, yeah, it certainly seems like the roadmap is starting to be drawn in ink as opposed to paper or pencil and paper. So this is something that we're definitely going to follow along with. Some really heavy-handed cases that the Supreme Court could potentially take, this one being included. So thank you, though, very much, Costas, for coming on and sharing sharing this insight with us. I know you're a busy guy, but I do appreciate it.
Yeah, no problem. Always a pleasure. Thanks for having me on.
Absolutely. And guys, if you like this content, you find it valuable in understanding the Second Amendment litigative process, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms to push them out as far as we can, as we want to keep our eye on the ball, especially these cases that affect us here in California. So thanks again, guys, and we'll see you on the next one.